Sorry, forgive my phone in the background. So I was reading through some stuff. I was reading through a car contract because I was trying to figure out, their little arbitration clause that they got on there. So for those of you who are just now learning about arbitration and wanted to get the basics before you actually choose um, a company to go through or use their laws, company laws. I think there's like three or four different types of arbitration companies that have a rundown and that can actually help you if you want the help. But I came across this. It was actually in my car contract. It was an arbitration clause, and it is extremely important to know this. I really only have 29 minutes now. I'll make it 30. But I want to get this read a little bit so that we can get a bigger picture of what we're dealing with when we're doing these commercial transactions and arbitration and all of that good stuff. Because the more we know, the more we can handle these people. So this is 9 USC Chapter 1. This is part of general provisions. I am going to, of course, go through each and every one because I don't like to miss a thing. Of course, as you guys know, click on those blue links and everything. And make sure you don't leave anything untouched because remember, they don't expect us to know these laws. They don't expect us to know what our rights are when it comes to the contracts because you guys know everything we do is a contract. That's all this world is based on. This is a commercial commerce, however you would like to put it. This world revolves around money. So everything we do from the moment we are spit out of a woman, you know, contract right there. So we don't need to be missing any parts of it. And we got to understand what our rights are. I have not read this. Like I said, I just went through. I was reading my a car contract of mine, and I was checking out the arbitration clause, and they put non USC one in there. So I have not read it, but let's get into it. Non USC one maritime transactions. Most of y'all know about maritime. In commerce, define exceptions to operation of title. Hmm. Maritime transactions are herein defined, means charter parties, bills of lading. Ooh, ooh. Try not to talk so much. Of water carriers, remember. Agreements relating to wharfage, supplies furnished vessels, or repairs to vessels collisions, or any other matters in foreign commerce, which, if the subject of controversy, would be embraced within admiralty jurisdiction. Yeah, remember. Yeah, most of y'all know. Commerce, as herein defined, means commerce among the several states, see states with capital S, or with foreign nations, or in any territory of the United States or in the District of Columbia, or between any such territory and another, eh, or between any such territory in any state or foreign nation, or between the District of Columbia and any state or territory or foreign nation. But nothing herein contained shall apply to contracts of employment of seamen, railroad employees, or any other class of workers engaged in foreign or interstate commerce. And if you guys know where the true United States is, then you know you are honestly operating in a foreign jurisdiction. If you know what a real United States is. Now, if you live in, the real United States, then I don't know what to tell you. But for the rest of us, you know, 9 USC 2, validity, irrevocability, and enforcement of agreements to arbitrate. A written provision in any maritime transaction or a contract evidencing a transaction involving commerce to settle by arbitration a controversy thereafter arising out of such contract or transaction. I'm going to pause right there, and I want to say, in the contract that I was reading, it specifically stated in the arbitration clause that um, you cannot do any type of remedy without using arbitration. And a lot of us were doing so many different types of remedies, sending affidavits and all this other stuff, doing tax forms and everything. But mine specifically, and it could be a lot of others because I know most of these contracts are nothing but the same piece of paper. Just they just type, your information and their new information in it. So it literally said that you can't try any remedies. I don't know why it would say that, but you can't try any remedies without arbitration, which is probably why with the finance company we always get into an argument. So, um, where did I stop? I don't know. Okay, well, or the refusal to perform the whole or any part thereof, or an agreement in writing to submit to arbitration an existing controversy arising out of such a contract, transaction, or refusal shall be valid, irrevocable, and enforceable, save upon such grounds as exist at law or in equity for the revocation of any contract or as otherwise provided in Chapter 4. And for me, I'm just going to talk while I'm navigating. For me, I wanted to just cancel my full contract. I wanted to revoke it, rescind it, everything, because I don't mind doing business with people. I don't mind it, but for me, I don't like doing business with shady people. And apparently the majority of these corporations that have been around for so long are the shadiest motherfuckers around. So yeah, I can't. They got motherfuckers working for them that don't even know the law, and they thinking you the stupid one. When they really the stupid one. So I want it out. I didn't even want the goods or nothing. I don't even want all that shit. You can take it all back. Just I want out, and that's going to be an argument. But this is why we're still learning. 9 USC 3 stay of proceedings were issued therein referable to arbitration. In any suit or proceeding be brought in any of the courts of the United States upon any issue referable to arbitration under an agreement in writing for such arbitration, the court in which such suit is pending upon being satisfied that the issue involved in such suit or proceeding is referable to arbitration under such an agreement, shall, on application of one of the parties, stay the trial of the action until such arbitration has been had in accordance with the terms of the agreement, providing the applicant for the stay is not in default in proceeding with such arbitration. Failure. 9 USC 4 failure to arbitrate under agreement, petition to United States court having jurisdiction for order to compel arbitration, notice and service thereof, hearing and determination. A party aggrieved by the alleged failure, neglect, or refusal of another to arbitrate under a written agreement for arbitration may petition any United States District Court, which, save for such an agreement, would have jurisdiction under Title 28 in a civil action or an admiralty of the subject matter of a suit arising out of the controversy between the parties, for an order directing that such arbitration proceed in the manner provided for in such agreement. 5 days notice in writing of such application shall be served upon the party in default. Service thereof shall be made in the manner provided by the Federal Rules of Civil Procedure. The court shall hear the parties, and upon being satisfied that the making of the agreement for arbitration or the failure to comply therewith is not in I want to make sure issue, the court shall make an order directing the parties to proceed to arbitration in accordance with the terms of the agreement. The hearing and proceedings under such agreement shall be within the district in which the petition for an order directing such arbitration is filed. If the making of the arbitration agreement or the failure, neglect, or refusal to perform the same be an issue, the court shall proceed summarily to the trial thereof. If no jury trial be demanded by the party alleged to be in default, or if the matter in dispute is within admiralty jurisdiction, the court shall hear and determine such issue. Where such an issue is raised, the party alleged to be in default may, except in cases of admiralty on or before the return of the day of the notice of application, demand a jury trial of such issue, and upon such demand the court shall make an order referring the issue or such issue, and upon such demand the court shall make an order referring the issue or issues to a jury in the manner provided by the Federal Rules of Civil Procedure, or may specifically call a jury for that purpose. If the jury find that no agreement in writing for arbitration was made, or that there is no default in proceeding thereunder, the proceeding shall be dismissed. If the jury find that an agreement for arbitration was made in writing and that there is a default in proceeding thereunder, the court shall make an order summarily directing the parties to proceed with the arbitration in accordance with the terms thereof. I'm just whipping on through this. 9 USC 5, appointment of arbitrators or umpire. If in the agreement provision be made for a method of naming or appointing an arbitrator or arbitrators or an umpire, such method shall be followed. But if no method be provided therein, or if a method be provided and any party thereto shall fail to avail himself of such method, or if for any other reason there shall be a lapse in the naming of an arbitrator or arbitrators or umpire, or in filling a vacancy, then upon the application of either party to the controversy, the court shall designate and appoint an arbitrator or arbitrators or umpire, as the case may require, who shall act under the said agreement with the same force and effect as if he or they had been specifically named therein, and unless otherwise provided in the agreement, the arbitration shall be by a single arbitrator. (9 USC 6). Application heard as motion. Any application to the court hereunder shall be made and heard in the manner provided by law for the making and hearing of motions, except as otherwise herein express provided. 9 USC 7, witnesses before arbitrators, fees compelling attendance. The arbitrator selected either as prescribed in its title or otherwise, or a majority of them may summon in writing any person to attend before them, or any of them as a witness, and in a proper case to bring with him or them any book, record, document, or paper which may be deemed material as evidence in a case. The fees for such attendance shall be the same as the fees of witnesses before the masters of the United States courts. Said summons shall issue in the name of the arbitrator or arbitrators, or a majority of them, and shall be signed by the arbitrators, or be directed to the said person, and shall be served in the same manner as subpoenas to appear and testify before the court. If any person or persons so summoned to testify shall refuse or neglect to obey said summons, upon petition, the United States District Court for the district in which such arbitrators, or a majority of them, are sitting may compel the attendance of such person or persons before said arbitrator or arbitrators, or punish said person or persons for contempt in the same manner provided by law for securing the attendance of witnesses of their punishment for neglect or refusal to attend in the courts of the United States. Sorry, somebody's shooting outside of my house. 9 USC 8 proceedings begun by libel and admiralty and seizure of vessel or property. In the basis of jurisdiction be a cause of action otherwise justiciable in admiralty, then notwithstanding anything herein to the contrary, the party claiming to be aggrieved may begin his proceeding hereunder by libel and seizure of the vessel or other property of the other party, according to the usual course of admiralty proceedings. The court shall then have jurisdiction to direct the parties to proceed with the arbitration, and shall retain jurisdiction to enter its decree upon the award. 9 USC 9 Awards of Arbitrators Confirmation Jurisdiction Procedure. If the parties in their agreement have agreed that a judgment of the court shall be entered upon the award made pursuant to the arbitration, and shall specify the court, then at any time within 1 year after the award is made, any party to the arbitration may apply to the court so specified for an order confirming the award, and thereupon the court must grant such an order unless the award is vacated, modified, or corrected as prescribed in sections 10 and 11 of this title. If no court is specified in the agreement of the parties, then such application may be made to United States Court in and for the district within which such award was made. Notice of the application shall be served upon the adverse party, and thereupon the court shall have jurisdiction of such party, as though he had appeared generally in the proceeding. Very interesting. That's how they trap us in a lot of things. If the adverse party is a resident of the district within which the award was made, such service shall be made upon the adverse party or his attorney as prescribed by law for service of notice of motion in an action in the same court. If the adverse party shall be a non-resident, then the notice of the application shall be served by the marshal of any district within which the adverse party may be found, in like manner as other process of the court. I will stop it there. So I would definitely go back and reread a lot of that, especially like I want to say 1 through 5. I want to say 1 through 5. Read 1 through 5. I tend to always go over what I really need, but hey, it's always, like I said, it's always good to know a little more. Yeah. If you are going to be dealing with arbitration, let me grab those names of the arbitration companies, and I will make sure I update them and put them in the description of the video. Let me see here. Ooh, one page. All right. Let's see. I'll just read off what mine says. You may choose the applicable rules of the American Arbitration Association, which is the AAA. Their website is www.adr.org. JAMS, which is JAMS, or another arbitration organization, subject to your approval. We waive the right to require you to arbitrate an individual claim if the amount you seek to recover qualifies as a small claim under applicable law. You may obtain a copy of the rules of the AAA by visiting its website, which again is www.a d as in dog .org, or of jams, J-A-M as in Mary, S as in Sam, by visiting its website at www.jam as in Mary, S as in Sam, A, D as in dog, R as in Richard.com. You can also refer to the websites to learn how to file for arbitration. I'll read this last paragraph as well. The arbitrators shall be attorneys or retired judges and shall be selected in accordance with the applicable rules of the chosen arbitration organization. The arbitrator shall apply substantial governing law and the applicable statute of limitations. The arbitration award shall be in writing. The arbitration hearing shall be conducted in the federal district in which you reside or such other place convenient to you as required by the rules of the chosen arbitration organization. If you demand arbitration first, you will pay the filing fee if the chosen arbitration organization requires it. We will advance in or pay any other fees and costs required by the rules of the chosen arbitration organization. So, yes, if you're not getting any remedy with some of these contracts, these companies, say for instance your car company, you might want to switch on over to arbitration. Make sure you got all your facts together. Go check out one of those websites. Read the course USC 9, 1 through 5, of course. But like I said, it's always good to just go all the way out. um of course, once I come across anything else, I'm going to start putting more stuff out there because I've been very timid on. But knowledge is knowledge. So I'm just, I got to get it all out there because it's killing me inside. But you know what? Till next time. Love you guys. Bye.